Good morning. Please be seated. We are here today for oral argument in Moore versus Murphy Elementary School District. Our cause number is CACV 13088 and CACV 130142. They're consolidated. And each side will have 20 minutes. Council, you'll be responsible for watching your time if you want to reserve a portion for rebuttal. We have conference this case, and we look forward to your argument.
Thank you, Your Honor. I'm Gary Lassen for the appellant Paul Moore, Paul and Lydia Bustamante Moore. This case has been extensively briefed, and I want to make sure that I focus on where I have learned problems or questions have arisen at in the various courts, the various levels. My intention is to reserve 7 minutes for rebuttal, and I'll keep attention to the time. Importantly, this is indeed two cases, but the first of which was filed actually and served before the Murphy School Board took its action to bring charges. In fact, it was filed on the same day, and the board was served on November 9th, 2009, the night that it later went ahead and adopted charges. And the focus of the complaint seeking declaratory and injunctive relief, and I would submit still a dispositive issue, is the fact that Dr. Moore had bargained for and given consideration for an agreed upon suspension without pay. And so that's really what the focus of the first complaint was, seeking judicial enforcement of that. And importantly, several of the matters that later become important and part of then the administrative appeal had not yet even occurred. But it's our position that the accord and satisfaction from the agreed upon suspension serves as a bar and precludes the board from having jurisdiction to move forward. Importantly, Yes,
Mr.
sir.
Lassen, was that issue, the accord and satisfaction argument, was that raised in the administrative case, administrative
Yes.
proceeding?
It was raised in the administrative case, and actually Judge Donahoe, at oral argument, began with a lot of questions about that.
Okay, let's assume it was raised, okay, and it was wrongfully raised. At what point did you appeal that decision?
I'm sorry.
When did you appeal the decision to this court? Let me go back.
Okay.
How does this court have jurisdiction over that appeal?
Okay, that case was timely appealed. As it turns out, a motion for
A motion for new trial was filed?
a motion
correct?
for new trial was
Was
filed.
was that timely filed?
Yes, and there
Within-
was no signed minute entry. And so at the time the other case was proceeding, the argument was made in front of Judge Anderson.
Correct. Let me go back.
Okay.
You have never appealed from the judgment entered by Judge Donahoe, the signed judgment, correct?
We appealed from the denial of the motion for new trial
I thought you.
and the judgment. The notice of appeal is from
I thought you
both.
appealed from the denial of the Rule 60C motion, which was brought approximately 18 months after
Correct.
the final judgment. So wouldn't if we have jurisdiction,
Right.
wouldn't our review be limited to those issues you specifically raised in the Rule 60C motion?
Yes, except that they were the same issues that were raised before,
But
the
understand-
same legal
yeah.
issues.
Understand, but
that-
you understand that we're looking at the Rule 60C from a different
Correct.
lens than we do at a normal
Correct.
Challenge to a judgment.
Okay. But in terms of that, you know, the notice of appeal itself references the judgment and until such time as the letter later, well, it is our position that in both cases there's a lack of jurisdiction that was properly raised at every stage and as part of the Rule 60C as even more substantially learned in discovery in the other case regarding the open meeting law violations. But going back to your original question, Judge Donahoe asked about that, and then, you know, that was substantially briefed before him, and he says, I'm not going to address the settlement agreement. Judge Burke at that time has that issue before him. It's my position, and it was our position in the Rule 60C as well, that it was wrong to not address the fundamental jurisdictional issues, that the nature of the way it was characterized by Judge Donahoe and then later Judge Herod was very, very narrow. And that was improper. And if any kind of administrative appeal, if there's a challenge to the jurisdiction of the body, the appellate jurisdiction of the Superior Court is no greater than that of the administrative agency from which the appeal is taken. And it was our position all along, at every juncture, in every proceeding, and indeed before the hearing officers who said we don't have jurisdiction, this was two separate hearings, to consider this, that the settlement agreement was preclusive. Secondly, the position taken by counsel for the board initially and throughout the initial proceeding prior to the case being removed and them being substituted out was that these legal issues, if you will, and this is their arguments in front of Judge Garcia, can always be raised in court after the administrative body conducts a hearing. But you can't stop the administrative process. The problem with that, and it was raised initially in the original lawsuit, is that the statutory scheme itself doesn't apply. 15-530.
Let's assume you're correct. It does
Yes.
not apply.
Correct.
Because, in fact, Dr. Moore negotiated a contract with the board, and it says what the procedures are. It lays out the procedures
Right.
for terminating his contract. But what's the harm in giving him more process than he was owed?
Your Honor, because it's not necessarily more, it's different. It is allowing a party to the contract complete control over the process. They are determining, not collectively, not in terms with the contract.
But what conflicts with the contract? What did they do you think conflicts with what he was owed under the contract?
What they did is they set about a process whereby they picked a hearing officer, they brought charges publicly.
But they didn't even have to do that, presumably. They could have just met in executive session and made this decision?
Well, they had an obligation to deal in good faith. There's a good argument as well that they have
But didn't they do that? Didn't they even get a second hearing officer? I'm still not following exactly what they've done that would be inconsistent with what he was owed under his contract.
Well, under the contract itself, if you read the express language of the contract, it's pretty clear that if they use that termination, they have to pay him the balance of the contract. Plus, they do that privately.
But not
They don't make it public.
Not if it's for cause.
Well, that's an ambiguity, and I didn't write the contract, and I don't know who did.
How is that ambiguous in the contract?
What?
If he's terminated for cause?
Well, what is cause?
Did you argue that he was not terminated for cause?
Yes,
or did
we
you
did.
argue that was also an argument? Are you arguing that on appeal?
Yes, we argued that they did.
Challenging, you're basically challenging the merits of the
Well,
hearing officer's ruling then?
well, no, what we're saying is he was already punished for that, is our principal argument. You can't punish someone twice for the same offense.
That sounds like a double jeopardy argument.
It is analogous to double jeopardy.
Why does that apply here? If, for example, there's just, there's public outcry, and it would just make it extremely difficult for someone to operate with any kind of confidence, with the community having any confidence in the person. Wouldn't that be a basis for taking further action?
Absolutely not.
What about
Public
the
outcry
symbolic-
is not sufficient. They entered into a contract on September 28th. He gave up his right to a hearing that he would otherwise be entitled to have. They could not suspend him for 30 days without pay as a public employee for a term without granting him a hearing.
Under what statute or what provision? Under the contract, it says nothing about that, under the contract. It says nothing about 30 days
Okay, but
suspension.
what they were doing there was not under the contract, but they would, there's no way you can,
Counsel, aren't you saying that they can't use these statutes to discipline him, but if they do, then they have to
But-
abide by the statutes? Is that the argument?
no, what I'm saying is constitutionally under Loudermill, you have a property interest and a liberty interest, which he never was given an opportunity either to address, to have a due process hearing if you are separated from your employment for more than 10 days. That was never.
He didn't dispute the 30-day suspension, right? Didn't he? He agreed to that?
He agreed to that in exchange for it being final. That night, when they said, well, Mr. Hawes says to him, and the partial transcript is available, he offered 5 days. And then they said, no, 30 days. And then he says, well, can I come back to work and still lose that money because I need to get back to my duties? And they go back and forth, and they say, no, it's got to be 30 days. And he began serving that the next day. And he served the whole 30 days without pay. He suffered the consideration. He also lost a lot of pay, or a lot of,
Wasn't the pay returned?
just the base pay. He also had, as many of these employees have, all kinds of dues paid for him, allowances.
Counsel, these allowances and dues, is that in the record? Is that,
Yes, it absolutely is.
In
It
response-
absolutely is. It was part of our motion for summary judgment. I've cited it in the brief. It include, they didn't make his annuity
but
payment.
when Dr. Moore received word that the money had been redeposited, did he ever make a tender back to the district and said, time out, I'm giving you this money
Right.
back right now, here's the check?
The answer is no, but the lawsuit had already been filed. They were required to comply with the rules of civil procedure to have a valid settlement agreement signed by him. They just deposited it, and at that point, he's already suffered that, and that was he had to resign from many of the organizations that the district paid for directly. Now, the answer to the question you posed is a good one, and that is he really did that in the concept of putting it behind him once and for all, and that was the context in which the negotiation occurred on September 28th. And then the board took final action. In answer to your earlier question, couldn't they had no power once that contract is performed to partially performed even, to rescind it. They were bound by that. Now, you talk about the publicity ruckus. These events that form the basis of the suspension occurred, year and a half or so prior. And there was a dispute, and he had defenses that he waived in the context of being able to get it behind him, to put it all behind him. And then all of that to some degree, becomes moot because the lawyer that negotiates the settlement is all of a sudden out of the picture, and on August 8th, a new lawyer who is never, ever hired meets with the board.
August 8th, or
August 8th.
the agreement was September 28th, is that?
I'm sorry, October 8th.
Okay.
Excuse me, I apologize. In a, quote, emergency session. No compliance with the emergency provisions of the open meeting law ever occurs. The agendas are fatally defective. On that meeting, on the 28th, they have a motion coming out of executive session to take further action consistent with what we discussed behind closed doors. The open meeting law violations themselves of October 8th, 28th, and 9 require voiding the subsequent action to terminate Dr. Moore. They have never, ever been substantively corresponding. The board never, ever even provided the minutes. They even argued that the redacted minutes didn't form a sufficient basis of consideration, evidence in agreement, but yet they never provided to any court copies of the minutes. In addition, we've also argued that the breach of contract, well, there's also other problems with the process. They unilaterally selected 2 hearing officers. They had a lawyer who first acts as lawyer to the board, then she becomes the prosecutor, then she becomes lawyer to the board, and then they defend the litigation. Well, under Taylor versus Arizona Law Enforcement, cited in Hamilton versus City of Mesa, that's just legally impermissible.
Even with, given the contract that, that he's entered into with the district?
Well, let's say they followed the contract. Maybe we'd have a different case. And I would submit we would. But it's not a question of what if they had followed the contract. They didn't. They chose to ignore the contract. Why did they do it? They did it to humiliate him. The whole context of the contract provision is to settle your problem quietly behind closed doors with the superintendent and the board. Whether or not he gets his balance of contract, it's apparent that there's some kind of good faith obligation to have a parting of the ways. What typically happens in those cases is you agree upon a procedure. Let's submit it to an independent hearing officer if need be. I have, practiced in this area, for 30 plus years. I never ever have used 15539 to fire a superintendent. That by and of itself violates the language of the statute. You cannot imply that someone else can bring the charges other than the superintendent. Had they said, okay, we'll use the process, we would have had a different case, but we don't have that. They took public action to embarrass, humiliate, trash him. And that's part of the contract action in a breach of contract claim that Judge Burke said is subsumed in an administrative appeal. The administrative appeal solely addresses a very narrow issue of whether there's sufficient and just cause under the statement of charges. And that was mooted by the agreement and the open meeting law. The open meeting law violations are egregious, they're palatable, and the fact that these could exist in 2009 after all the repeated efforts by the Attorney General's office to preclude this kind of agenda and shenanigans is amazing. I have very little time to reserve, but I will.
Thank you.
Good morning, Your Honors. Eileen Gilbride for the defendants. I kind of don't know where to start here. I will ask for your questions, and I guess I'm just going to go big picture here.
Go ahead.
Go ahead, go
We
ahead.
get to an order asking a specific question. Do
Yes.
we even have jurisdiction in light of Anderson versus Valley Union High School?
And you don't have jurisdiction over the lower court appeal. It's the first time in 30 years I missed a jurisdictional issue. I hope to never do it again.
Counsel,
You're at-
focus on Anderson for a little bit. The only concern I have regarding following Anderson would be just the plain language of 12-543 that refers to the decision of the board being final unless the certificated teacher files within 30 days of, if
Right.
we're talking very plain language.
Yes.
It refers to a certificated teacher.
Right.
Wouldn't it require us to extend that to other, let me ask you this. Is Dr. Moore a certificated teacher within the definition of the statute?
He's not a certificated teacher, but if you look at ARS 341A22, that's the statute that outlines the powers of the board, and it says that for administrators, conduct serious enough to constitute cause for dismissal are handled under this title 15-531. And so that is the title that was used, even though that title, like you said, gives him much more due process than his contract required. So honestly, whether you treat this as an appeal or treat it as a special action doesn't matter to me, because whether you treat it as an appeal that doesn't have jurisdiction or you treat it as a special action, it lacks merit anyway. So however you want to look at the lower court appeal is honestly fine by me, because it just lacks merit. So you don't even have to reach that issue. You can decline jurisdiction. You can say it's an appeal. You can deal with it as a special action. Either way.
And either way, what is the scope of our review then is it a Rule 60C motion on the administrative appeal?
Yes, it is a 60C motion, and honestly, I'm not even sure that a new trial motion or 60C is appropriate from an appeal in an administrative appeal. But let's just say it is, and you're limited to 60C scope. The question is whether he raised a proper 60C motion. And if you look at the 60C motion, all it does is sort of throw out arguments and attach briefs from the civil case. I didn't even know where to go from that. But it doesn't say, there's 60C has specific subsections 1 through 6, and I'm not even sure which one would even apply. Honestly, counsel's briefs are so over the map, it's difficult to determine what's an appropriate argument or what he's arguing at any particular time. If you want to treat it as a special action, if you want to consider the arguments, really the only legal issue that he raised is whether or not the 15-539 procedure is an appropriate procedure to use. It is because of the definition. As I said before, it was 341A22. It gave him much more due process than he was entitled to under his contract. And the other argument is, how can that process be legal when it refers to the superintendent filing charges against the certificated teacher? You know, when the legislature says use this process for disciplining administrators, I think that shows the legislative intent that whoever is available, the assistant superintendent, to give the notice of charges to him is going to be fine. And if it's not, honestly, it's an issue that doesn't go to the appropriateness of the termination, because it would be a technicality that doesn't deal with the actual termination itself. He had plenty of notice of his charges. He was given personal notice of these executive sessions, and he doesn't claim to have been prejudiced by any of that.
So it appeared, or at least my understanding of Mr. Lassen's main two arguments were accord and satisfaction and open meeting law, and perhaps you could, or at least for my benefit,
Yep.
if you could walk through those two issues.
All right, so that deals with the civil case appeal. The accord and satisfaction, Judge Garcia knocked that out very early on in the case when she denied counsel a TRO and said, look, if there was no consideration, well, actually, she first said there was no accord and satisfaction, and then Judge Anderson, later in the same case, when he granted defendant summary judgment, said there's no contract, there's no consideration for this suspension, and they didn't have, according to counsel himself, the board didn't even have authority to suspend him for more than 30 days. If they didn't have authority to suspend him more than 30 days, they certainly didn't have authority to agree to suspend him for more than 30 days. And there was no consideration because he didn't give up anything in exchange. He didn't have a claim against the board that he was giving up in exchange.
Isn't he saying the consideration is he's giving up his pay for 30 days and these other benefits?
I think that's what he's claiming, but that's just the discipline. I mean, it wasn't something that he was giving up. He was paid for he took his pay afterwards when it was offered to him, and his suspension was expunged. And counsel is wrong on the record when he says that he wasn't paid everything. If you look at our reply in support of our summary judgment motion, we attached all these affidavits from the district personnel that said he got every penny that he was due to him. So that's an inaccurate representation of a record there.
Counsel, what did the board learn, if anything, new, or maybe not, maybe there was no new information, I'd just like to clarify that, after the 30 days suspension, or sort of what was the trigger that if it's public information or if it's in the record?
It's not in the record as to what they found out, but what the implication is that they were doing some additional investigation to see what else was out there. They did speak with counsel. A couple of the board members did. He tried to raise that as an open meeting law violation. Judge Campbell in the district court rejected that, said that he didn't state a claim for that. And the board I know that there was public outcry. You can read it in the public minutes of the public meetings. How can we do this?
But after September 20th, it seems like all of the information that forms the basis of the charges was known as of September 28th.
I don't know that for sure. The only thing that's in the record is, the police report and all of that was known. I'm not sure what other information came to light after September 28th and before October 6th, whenever it was that they decided to go into executive session.
Was the fingerprint card status in play at that time, as far as you know? I mean, whether in fact he had obtained a new or updated fingerprint card.
I have the timelines here. There's so much that goes on
I understand.
in this case. I believe he got his fingerprint card in September of 2009. If I'm correct, let me just, or it might have been 10 or 11. Honestly, I can look for that, but he waited when he told, I believe it was 09, because he was originally arrested in 07. His fingerprint card was suspended in January of 08. He kept telling the district that he was working on it. He didn't really apply until July 09, and then I believe it was reinstated in September of 09.
Okay, thank you.
If I could just try to clarify on the accord and satisfaction
Yes.
argument. Let's assume he immediately repays when the school district offers to give him back the money from the suspension. Let's assume he just immediately repays it and says, no, I took my suspension. Are you suggesting that he needed to have a formal claim against the district that he was waiving to be some sort of consideration for it? Wouldn't be enough for him to have just said, look, I went 30 days without pay was my consideration for agreeing not to be charged with anything further. Wouldn't
know,
that
in-
be a consideration?
In that case, which of course isn't this one, then I suppose he could argue that he would be being punished twice for this one.
So he doesn't have to have a formal claim against the district that he's waiving.
He has to have something that he does have to have a claim for something that he's giving up. Something that he's supposed to be giving, that the district owes him, that he's giving up in exchange. And there was no discussion of an exchange here, that the district was going to never, look at this again or would forever put this behind them. There was no discussion of that. There's no term like that. The district isn't giving up anything. The district is disciplining him for misconduct, which it could have done behind closed doors without even asking him, and probably, under the guise of no good deed goes unpunished. They had their counsel call him and said, look, we want you to be agreeable to this. Are you agreeable to it? That doesn't mean that there's a contract. There still has to be a give and take on both sides. The fact that he committed misconduct doesn't mean he was giving something up. It means he committed misconduct and was entitled to be disciplined for that. Other questions? I could go over some of the, you wanted to know about the open meeting law violations issue. There are no procedural irregularities. All I see in the briefs are sort of accusations, conclusory accusations that there's something wrong with the agendas.
Specifically about the allegation that there was an emergency meeting to hire Lewis and Roca. Was there in fact an emergency meeting, and when less than 24 hours notice to the public, or 48 hours?
No, not that I saw. There was an executive session on October the 8th. Dr. Moore was given personal notice of that executive session, that on October 6th there's a letter to him that we are going to meet on the 8th in executive session to discuss your employment and your contract. I'm almost positive that there is an agenda and a posted notice in the record on that. I do know, again, I believe it's in reply to our summary judgment motion. We have an affidavit from the gal who does the postings and said she posted all of the notices within time, and that is undisputed.
And it's also undisputed that Dr. Moore was given
Personal
notice,
direct,
whether either through a letter or otherwise.
It was a letter, and that is in the record.
Of the impending meetings.
That's correct, and that's our statement of facts in response to plaintiff's motion for summary judgment, Exhibit 34. You can find that letter. And it offers him that you can ask for this to be done in an open meeting, and he didn't. So, even if there's some procedural irregularity with the notice, and I can't find one, he hasn't specified what is wrong with the notices, but even if there were, it wouldn't invalidate the termination that came after, because it doesn't actually affect his termination. He was actually voted to be terminated in open session, in a public meeting, on November 9th. And so if there was some problem with the notice, and there wasn't, it wouldn't be sufficient to invalidate his termination. And you could really only go there if you are taking special action or appeal jurisdiction over the lower court appeal, because that is the judgment that you would be attacking, not in the civil case, which is why I tried to keep these two cases separate to begin with, because Judge Donahoe has a judgment affirming the termination, and in the civil case can't collaterally attack that judgment. So you can only go ahead.
I thought in the administrative case, I understand I thought as far as the open meeting law, allegations in the administrative case were limited to the hiring of Lewis and Roca. Is that what you're saying? But that would be a collateral attack going after those allegations. Or are you saying all open meeting law violations were encompassed in the
Well, I
administrative
believe
appeal?
what counsel and plaintiff are asking for is, because of the supposed open meeting law violations, you have to turn over the termination. It's the remedy that he's asking for. And I believe that's the remedy he wants for all of these claims, in the civil case, in the lower court appeal case. In the civil case, we can't do that. We can't collaterally attack the lower court judgment. And the problem with the lower court, the arguments in the lower court appeal, is that he didn't attend the hearing, and he didn't file any objections in the administrative hearing until after it occurred. And so Ben Hufford, the hearing officer, said, you know, this is too late. You didn't show up. You were present for the pre-trial, if you're the pre-hearing conferences. You didn't show up. You didn't call us. You didn't file objections. You didn't do anything. We're going to go ahead with the hearing. And they did. And then after he gets back to the office, here we have objections. We're not going to show up. And here's our legal objections. And he's like, you know what? This is too late. And all of these objections lack merit anyway. Then Judge Donahoe looks at that and says, what's wrong with that? You know, he didn't show up or make his arguments timely, plus his legal arguments lack merit. So that we're not going to collaterally attack in the civil appeal. Other questions? I like to deal with the minute I have left with the attorney's fee argument. And the only reason I want to deal with this is that plaintiff does not complain about the hours that were spent or the rate or anything like that. The only argument is that the fees were expended by the defendant's insurer. Now, that is not a viable argument. And the problem is that this court has twice before ruled in counsel's cases that that is not a viable argument. And that was in the Malone versus Dysart case in 2011. 2011 Westlaw 2118945. And in the Ellico versus Hackberry case in 2014. 2014 Westlaw 465848. And I just don't think that my client ought to be here expending tens of thousands of attorney's fees to defend these kinds of cases when arguments like this have already been laid to rest, even with this particular counsel. We'd ask you to affirm. Thank you.
Either the open meeting law is fundamental in jurisdiction and applies, or it's ought to be taken out of the books. And to not apply it here would be a travesty.
Counsel, even assuming a violation here, what remedy are you seeking?
The termination is void. There's no other option but that. And October 8th, I'll read from the minutes. I mean, you look at the agendas are just fatally defective. The motion is obviously prepared in executive session. They come out. There is no discussion. There's no compliance at all with Town of Chino Valley versus City of Prescott.
Town of Chino Valley, that was a case involving legal advice on a legislative matter. How does that
It applies squarely. It's executive session. Fisher versus Maricopa Stadium District, same thing. They made the decision behind closed doors with the attorney from Lewis and Roca. The public is deprived of the opportunity to know. There is nobody has a clue on October 28th, especially Dr. Moore and myself. What are they going to do? Nobody knew that. No one was directed to adopt statement of charges. Those are deliberations. But on your question earlier, the minutes of October 8th evidence an emergency item. I mean, they're being disingenuous here regarding the minutes speak for themselves. Mr. Murillo made the motion to accept the agenda. Mr. Grimes made the recommendation to add emergency item E.1.1 regarding Dr. Paul Moore. No compliance with the emergency provisions. Now, there's a fundamental issue here beyond the open meeting law. You have an ultra-vires act by a volunteer lawyer. And there was no information, no additional information. And back to the consideration issue.
In just 30 seconds.
He gave up his right to a due process hearing, to have the matter finished there once and for all. And instead of that, they trounce his reputation in public, and he has been unemployed since this date because of the public humiliation. The contract provision would not have resulted in that outcome. Thank you.
Thank you for your argument. We will take this matter under advisement and issue a ruling in due course.
Good job. Bill Hodgson, I don't know.
Oh, we might have met before.
Yeah, of course.
Nice to
Well, we
meet
were
you.
accepted. And you know Kevin Kelville, of course.
Yes, we met before.
Yeah.
Yeah.
Yeah, because I hit some of the interest and just the date. No worries. I'm so sorry. I got it. Okay. Yeah, this was great. Yes. I mean, I don't know if you have to, yeah, you should probably move. I was gonna say, it's the only one from today, so it's not like there's any confusion. But if they somehow, they probably list them somehow by case number, so. I apologize. Thank you, Justin. Did they get you your case?